Conflicting views of history emerge as U.S. opposes Warren DA in the medical marijuana suit, you guys. Oh, yeah, here we go. The Warren County District Attorney's Office attempt to overhaul the federal regulation of marijuana and firearms is becoming a debate over history as much of it is a battle over drug policy and the Second Amendment. In responding to Rob Greene's lawsuit filed in federal court in Erie, the U.S. Justice Department is contending that Greene has no foundation in the law or history, as he argues that users of medical marijuana like him should be allowed to have firearms despite the federal prohibition otherwise. Greene said history and the Constitution favor him when he sued in January and filed a request for a preliminary injunction in March. In quotes, says, history is devoid of any laws demonstrating a tradition of disarming individuals for using particular kind of medicine, such as cannabis, according to Greene's brief for a preliminary injunction. History does not support this total bar on the right to keep and bear arms, according to the brief, which refers to the language of the Second Amendment. In a brief filed on Monday, the Justice Department responded by arguing that the Second Amendment applies to law-abiding citizens and that the amendment has never prevented Congress from prohibiting unlawful users of controlled substances from possessing firearms, prohibitions codified in the Federal Gun Control Act of 1968. As long as the federal government continues to list marijuana as an illegal narcotic, holders of medical marijuana cards, even if Pennsylvania and other states have legalized medical marijuana, violate federal law if they possess guns, according to the Justice Department's brief. And the department's lawyer, Jeremy S.B. Newman, said in a brief that history supports the federal government. In quotes, he says, disarming unlawful drug users is consistent with the historical tradition of restricting firearms possession and use on the basis of intoxicating and the historical tradition of disarming groups of people who would present a danger with firearms, according to the brief. Greene's case is before the U.S. District Court Kathy Bassoon, who is based in Pittsburgh, but hears cases in the Erie Division of the Pittsburgh-based U.S. District Court of the Washington District of Pennsylvania. No hearing date has been sent. And in a quote from the U.S. Department lawyer Jeremy S.B. Newman says, disarming unlawful drug users is consistent with the historical tradition of restricting firearms possession and use on the basis of intoxicating and the historical tradition of disarming groups of people who would present a danger with firearms. Greene is the lead plaintiff as he sues with help from another plaintiff, the Washington state-based Second Amendment Foundation. They are suing the United States government, Attorney General Merrick Garland, and the directors of the FBI and the Bureau of Alcohol, Tobacco, and Firearms and Explosives. The plaintiff wants Bassoon to set aside the federal law that bars users of medical marijuana from possessing firearms. The plaintiffs also want Bassoon to grant a preliminary injunction to temporarily ban enforcement of the law while she considers the underlying lawsuit. The case is believed to be the first of its kind in the United States. A win for Greene would have a sweeping effect in Pennsylvania, one of 38 states to legalize medical cannabis, and a state where 500,000 people have medical marijuana cards, according to Greene's court filings. Greene, a Republican, was first elected in 2013 a district attorney of the largely rural 38,000 resident Warren County. He said in late December that he would not seek re-election after his current term expires in 2025, so he could focus on advocating for legalization and regulation of marijuana. Greene's lawsuit followed on January 23rd. He said in the suit that he has refrained from possessing firearms since he got a Pennsylvania medical marijuana card in May 2023. The suit and other case documents do not detail Greene's medical condition, and the legal conflict at the core of Greene's case exists because marijuana is not legal nationwide despite legalization of medical marijuana at some state levels. Marijuana, we know all of that, you guys. Greene is taking up his challenge as the U.S. Supreme Court has shifted its approach to the Second Amendment rights. Key to the strategy of Greene and his lawyers, including the Second Amendment Foundation's executive director, Adam Kraut, is the reliance on the Supreme Court's 2022 landmark ruling in the case of New York State Rifle and Pistol Association, et al. Versus Bruin. In a 6-3 decision, the Supreme Court in the Bruin case changed the standards for evaluating the constitutionality of gun control measures in holding that the Second Amendment protects the ability of law-abiding citizens to carry firearms in public. History must drive the review of gun restrictions, and Justice Clarence Thomas said in the majority opinion, in quotes, to justify its regulation, the government may not simply posit that the regulation promotes an important interest. According to the majority opinion, rather, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation. That standard is what has led Green and the Justice Department to invoke history as they establish their positions in the U.S. District Court in Erie. Well, you guys. Man, oh man, oh man. I feel like this is going to be a good day once this verdict comes out for cannabis and gun-toting cannabis lovers who love to toke and fire up in all different forms of ways. And this is Jason Beck for the High at 9 News. What do y'all have to say about this?
I think the federal government's on a slippery slope here, Jason.
I think it is. I agree with you, Dale. I think they're going to lose this case.
The standard that was set by the Supreme Court in that New York Kerry case, Bruin case, whatever you're talking about there, it added an extra layer. And our nation started in 1789, and it wasn't until, the 1960s or 70s that they finally decided to make possession of illegal drugs a way to stop people from having guns. So if you add that layer onto the test, then I don't know how they win this, because cannabis or marijuana wasn't illegal federally until 1937, and it wasn't until the 60s or 70s decided to make it something that restricts you from having a gun. Now, this is very important to all the vets that I represent out there that have PTSD, like smoking weed, because they're concerned that if anybody finds out, they're going to lose their gun rights. So they're watching this very carefully. I just think the federal government's blowing smoke up everybody's ass. They don't want to lose this. But I don't know that they have a decent argument based upon the Supreme Court standard that was just set.
Well, their argument is trash, Dale. Their argument is like it by the standard becoming that. I forget Thomas's direct quote of history must drive gun regulation or whatever, right? The way the Green is right. The plaintiff Green here is 100% right, because there is no historical context for it. And the historical context that the government tries to use here is when people in the Wild West were disarmed for being intoxicated, and they used to have like local rules and laws and stuff like that. That's completely different. If some dude is incapacitated and just falling out drunk with firearms in his hands, that's a totally different situation of why we're disarming that person, rather than somebody that has to use a medicinal herb.
Let's also clarify that too, though, Luke. Like, let's clarify what disarming in the Wild West meant too, right? Those first open carry bans existed in Wild West towns like Deadwood, but you know how they worked? When you were in the town limits, if you were drunk, the sheriff would come and take your pistol. If you went into a saloon, you hand your pistol to the bartender, and guess what? When you leave, they give you your gun back. It was not a permanent disarmament of people that because they were intoxicated or incapacitated. It was them saying that while you're out here drinking moonshine and drinking whiskey, you can't be strapped, which is probably a reasonable thing to say. But it wasn't like you can never handle a firearm again because you got drunk once at a saloon.
Let me also point out that when you got released from prison, they gave you back your guns too. And that was up through the 19th century. They didn't start taking your guns away for real after you were convicted until into the 20th century. So a lot of this, I mean, I don't want someone who's a violent criminal having his guns back. I think there are some things we can talk about here. Someone who smokes weed not being able to have guns, that's pulling shit right out of your ass. That's crazy.
Yeah, no, I agree, Dill. I think Green is going to score a big win for all of freedom-loving cannabis consumers across the country, and I think this is going to have rippling effects that we are all going to be able to benefit from, hopefully sooner than later.
Yeah, man.
Yeah, and on that,
we'll be able to tote while you toke.
That's right. Bang, bang, bang. You know what I mean?
Bang, bang.
Real firepower. You know what I'm saying? All that good stuff.
Responsible.
Exactly.